South Africa has a plural legal system, which means that it recognizes multiple sources of law, including Roman Dutch common law, legislation, and, importantly, African customary law. The Constitution of the Republic of South Africa, 1996, explicitly acknowledges this legal pluralism in Section 211, which provides constitutional protection for customary law and traditional leadership. Section 211 of the Constitution states, firstly, that the courts must apply customary law when that law is applicable subject to the Constitution and any legislation that specifically deals with customary law, and secondly, that customary law is recognized as a valid and independent system of law, but only to the extent that it is consistent with the Constitution. This is crucial because it allows African communities to have their traditional legal norms respected and enforced, but also protects individual rights by ensuring that customary law cannot violate constitutional rights like equality, dignity, and non-discrimination. In the B versus Magistrate Kailicha case, the Constitutional Court had to consider the rule of male primogeniture under customary law, which dictated that only male heirs could inherit property in intestate succession. The court found this to be unconstitutional as it violated the rights to equality, Section 9, and human dignity, Section 10, particularly for women and children born out of wedlock. As a result, the principle of male primogeniture in intestate succession under customary law was struck down. The Intestate Succession Act and the Maintenance of Surviving Spouses Act were interpreted to apply to all South Africans, regardless of the legal system under which they live. The case also reinforced a critical distinction in South African jurisprudence. Official customary law refers to the version written down in statutes or legal texts. Living customary law is the dynamic, evolving version practiced by communities. Courts are now encouraged to give effect to living customary law, which reflects actual community practices, even if it differs from written or official versions. So, in summary, South Africa's recognition of customary law within its constitutional framework shows a sophisticated balancing act. It respects the cultural and legal traditions of its people. It ensures these traditions do not violate constitutional values like equality and dignity. And finally, it creates a space where pluralism and human rights can coexist in a transformative environment.